SJC-12294, Brian Andriolo and others, v. City of Lowell.
Good morning. May it please the court, my name is Alan Rubenstein, and I represent the plaintiff appellants, who are 36 owners or former owners of condominium units at the Grand Manor condominiums in Lowell. Now, the principal issue presented by this appeal is when the statute of limitations, which is set forth in General Laws, Chapter 21E, Section 11A, Paragraph 4, begins to run. The trial court in this case put that issue to the jury, but the trial court, over the plaintiff's repeated objections, instructed the jury that it was the plaintiffs who bore the burden of persuasion of demonstrating to the jury that the statute of limitations had not run before this action was commenced. The jury then determined that the plaintiffs had not borne that burden that was placed upon them, and held that this action, or at least the claim that was brought under Section 5 of Chapter 21E, was barred by the statute of limitations. Now, the background of this is that at the beginning of 2009, hazardous materials were discovered at the site of the Grand Manor condominiums. Upon being informed of the existence of the hazardous materials, the Grand Manor Condominium Association retained a licensed site professional by the name of Joseph Giamallo to advise the Condominium Association concerning its legal obligations under Chapter 21E and the Massachusetts Contingency Plan. The hazardous materials were discovered in samples taken from an excavation in a very small area of the site.
In 2009?
This was at the excavation was done at the very end of 2008. The samples were sent to a lab for testing, and the record shows that the lab results were communicated. Actually, they were communicated to the excavation contractor first by a letter dated December 31st, 2008. So for the purposes of this case, I'm assuming that the Condominium Association found out about the existence of the contamination within a few days thereafter, at the very beginning of 2009. That's right.
So I think the core of your argument as far as when the statute of limitation runs is looking at the difference between damages in Section 4 and Section 5. But when you look at all of the permanence that you say is required for Section 5, but when you look at almost every case, maybe every case, whether it's the Mansfield case with the roof, or whether it's the legal malpractice case, the Cantu case, every single case seems to be when it is that the plaintiff knew or reasonably should have known. So what is it about this circumstance that takes it out of the overwhelming amount of cases? In Olson too, by the way.
Two things, Justice Lowy. First of all of those cases that you allude to are common law cases which are governed not by the statute of limitations in Section 11A of Chapter 21E, but rather of Chapter 260, Section 2A, or similar statute of limitations, which provides that an action must be commenced within 3 years of the time the cause of action accrues. And it's well established by lots of case law that in a common law context, a cause of action accrues as soon as the plaintiff is injured, okay? So as soon as the plaintiff is injured, the plaintiff can commence an action, and it makes sense that the statute of limitations should begin to run. Section Section 11A, particularly subparagraph 4, is very different because it contains very specific requirements that must exist. It doesn't say within 3 years of the time the cause of action accrues. It says that it must be commenced within 3 years of the time the plaintiff first suffers the damage, or within 3 years of the time that the person seeking recovery of such damage discovers or reasonably should have discovered that the defendant is a person liable under the statute, 21E, for the release of hazardous materials that caused the damage. So there are at least 3 requirements, whichever date is later. So there are at least 3 requirements that have to be met under the statute before the statute will begin to run. And as long as you've raised the issue, I also want to say that the plaintiffs in this case are not relying on the discovery rule or the common law discovery rule. The common law discovery rule comes into play only in the case where the statute of limitations would have otherwise run. And it's sort of like an equitable lifeline to the plaintiff, where the plaintiff introduces new facts to take the case outside of the statute of limitations.
Maybe this is an oversimplification, and if it
Sure.
is, I'll trust you to let me know. What you're really saying is that the gravamen of Section 5 is permanent damage. And there's no way to know that the damage is permanent at these preliminary stages when you're dealing with 21E.
Well, I'm saying that, but
I'm asking you, that as I understand it is your point.
yes, but I think at least 2 cases of this court and 1 case of the appeals court, Guarantee First versus Textron, Hill versus Metropolitan District Commission, which are prior decisions of this court, and the appeals court decision in Black versus Coastal Oil New England, support that proposition. Let me explain. In Guarantee First, the court held that common law measure of damage concepts applied to claims made under 21E, particularly 21E Section 5. And the court explained in Guarantee First that the common law drew a distinction between property damage, which is reasonably curable by repairs on the one hand, and property damage, which was not reasonably curable by repairs on the other hand, i.e. permanent property damage.
But those aren't statute of limitation cases, right? None of those are statute of limitation cases.
No, they're just measure of damages cases, Your Honor, but
yeah, but I mean, because we have to draw distinctions between recovery costs and measures of damages in these 21E cases, right?
well, Your Honor, in the context of the common law, the only distinction or the only significance of drawing a distinction between temporary property damage and permanent property damage is how you calculate the amount of the damages. Whether the damage is temporary or permanent under the common law, the cause of action is the same.
But isn't it as a practical matter, you've got these very lengthy recovery efforts going on, and different people contributing to the recovery costs. So you don't want to sort of figure out what property damage a Section 5 claim is until after you've sorted out who's, remediating, right?
Well, not only that, not only don't you want to have to, but in many cases you can't.
Right, but that's somewhat a different question. I mean, I do see your point as a practical matter. How are you going to bring a Section 5 claim with any kind of precision when you're doing all this remediation for years, right? I get that point.
And you don't know whether, as a result of the remediation, you're going to be able to fully remove the contamination.
But the way you characterize damage, though, you almost can't do it until after trial. I mean, right, you have to, I don't know.
Well,
I don't read the statute of limitations. I mean, you've done a sort of a very clever way of doing that, but wouldn't you have to wait until after trial almost to figure yours out?
well, not if you adopt the rule that we're seeking, because then the statute of limitations wouldn't begin to run until you became aware one way or another whether the property damage is permanent and temporary.
so
And
you're-
if
so
the
you're-
statute doesn't begin to run, you wouldn't commence a lawsuit, and then you wouldn't have to face that issue before trial.
I'm just trying to understand as a practical matter how it would work, because these cleanup cases are extremely complex. You've got multiple responsible parties contributing money. So you're saying until all of the cleanup and remediation is done, we don't know whether you could wait 10 years, 15 years for this?
No, I'm not saying in every case, until all of the cleanup and remediation is done. I'm saying until one reaches a point during that process where it is reasonably known one way or the other whether the property damage is curable by repairs or is not.
I assume you say began in June of 2011.
Well, June of 2011, as we explained in our brief, is when the city's LSP, TRC Environmental, hired a subcontractor to perform ground penetrating radar tests, and they determined that the contamination existed over the entire site. So I think TRC knew by June of 2011 that the damage was permanent, but that information did not become publicly known until the Hager geoscience report was incorporated into the Phase 2 report.
So, but this is a very unusual statute in that if the result of the LSP had said, we can fix this, it may cost us $3 million, but we can restore the property to its previous, to basically become a clean property again, then Section 4 would cover it.
Correct.
Because it would be response costs. And then the statute of limitations is that you don't need to bring your suit until 3 years after the last of the response costs have been expended.
That's true.
So if it turns out, if the LSP here had said, we can fix this, you would have had plenty of time to file your action.
Absolutely.
So what do we do? So you're saying then that since you did not know that your damage was actually property damage under Section 5 until you learned that it could not be remediated, then that's when the statute should run.
That's exactly what we're saying. And
Now, did the judge, I was trying to see, the judge's jury instructions don't speak of any definition of property damage. Is there anywhere in the, but they reference earlier instructions to the jury. Did the judge ever define what property damage under Section 5 was? Because you did receive damages under Section 4.
Absolutely.
And that was for the earlier efforts to evaluate the property, I gather?
That was for both the early efforts and also for legal fees that were closely associated with the response actions.
So the judge spoke of Section 4 damages, and you got those, and those did not have any statute of limitations issues because the
correct.
clock starts only at the end of those, at the payment of those. But did the judge ever define what property damage under Section 5 was for the jury?
I don't remember the judge including such a definition in her instructions, but I think we all assumed that putting aside whether it's temporary or permanent, that real property is damaged as soon as it comes into contact with hazardous materials.
But which is what no doubt the jury understood, but that you say is wrong.
Well,
That you say
I'm
under
saying
Section
that
5 is
doesn't.
not the way we should interpret damage under Section 5.
No, I'm not saying that's wrong. I'm saying that with respect to subsection 4 of Section 11A, which is only applicable to Section 5A3 claims brought by private persons, that property damage means more than just that. It means real property that has come in contact with hazardous materials and which cannot be reasonably cured within a reasonable time and for a reasonable cost.
And my question to you is, that is what the jury, you claim, should have been deciding, But I don't see anywhere in which there was any discussion at trial over what the question should be for the jury under Section 5 in terms of what their decision should be.
Well, the jury wasn't deciding that only because the judge rejected our view of what subsection 4 of Section 11A means, and simply put to the jury the question of whether the statute had run based on the formulation set forth in Tejeda versus Varian, in which this court really didn't consider the argument of whether 11A4 doesn't begin to run until it's known whether or not the damages are permanent.
Okay, I'm still, I mean, you're here because you're saying we should not respect the jury's verdict because there's an error of law.
That's true. But
Okay,
the error of law was
and-
made by the court, not in
Right,
her instructions.
Well, I mean, the judge's instructions are the reflection. It's the jury who made the factual finding, and the instructions to the jury is the declaration of law to the jury as to here is the finding you should make. And I can't see where the discussion was that led to what the judge said, here is the law, members of the jury, that you should use in making this factual finding of whether the statute is run.
There was really no factual dispute in this case, Justice Gantz, that the plaintiffs could not have known prior to October 10th, 2000, or prior to the time the Phase 2 report was filed, that their damage was not reasonably curable by repairs. There's no dispute that they couldn't have known that before June of 2012. So if the judge had embraced the theory that I'm now advocating, the issue of statute of limitations wouldn't have gone to the jury in the first place. Instead, the judge rejected part and parcel that entire theory and put the statute of limitations issue to the jury based on an entirely separate theory.
All right, I'm sorry, and I cut off Justice Gaziano. So.
I just want to have you backtrack for a bit.
Sure.
Justice Lowy had asked you why we don't apply the new or had reason to know standard, and you told us there were two reasons. The first was because we're not dealing with the common law statute of limitations, it's the statutory. You told us that's number one, right?
Yes.
I don't know if you got to number two when we took you down the rabbit hole.
I think number two was, this is not a discovery rule case. I mean, that argument that this is not a discovery.
You had disclaimed, you told us it wasn't discovery, but that was going to be your number two.
Yes,
Okay, I just want to be clear. Thank you.
right.
Can I ask one last question? So is there any guidance from the regulatory agencies on the statute of limitations issue? Is there anything in any of the regulations on this?
I'm not aware of any such guidance, Justice Kafker. Now, of course, we have a second argument, which is the judge erroneously put on the plaintiffs the burden of persuasion with respect to the statute of limitations. But because my time is up, we will rely on the argument set forth in our brief.
All right, thank you. Mr. Carlson?
Thank you. Thank you, Your Honor, and may it please the court. Michael Carlson for the City of Lowell, the defendant and appellee. So plaintiffs have brought before you two pretty radical propositions. They're asking you to rewrite the statute of Chapter 21E to include a new requirement for permanent property damage. And secondly, they're asking you to overturn...
Wait, I'm sorry. I'm going to stop you there. Isn't it clear from the case law that Section 5 is limited to permanent property damage and does not include response costs?
It does not, certainly does not include response costs. You're correct. And at the time of trial, it may be the case that the plaintiff is or is not entitled to private property damage, permanent damage. Those are the only awards that can be awarded at the time of trial under Section 5. That's correct. But that's an entirely different question as to when the statute accrues and when the cause of action accrues. Basically, it's a common feature of trial that there's an assessment of damages. What is the appropriate measure of damages to be assessed at that time of the case? But that doesn't, as Justice Kafker mentioned earlier, that doesn't throw the question of damages all the way back to the beginning of suit and say a plaintiff is out of court unless he can allege at the time reasonable knowledge of permanent damage. Basically, that's an assessment that's made at the time of trial, and that's
Well, I mean, or it could be made when there has been a licensed site analysis, which says we can't fix this. This is now simply permanent damage and it's too expensive to fix.
That's correct, and that would be evidence that would be appropriately assessed at trial as to whether the plaintiff is entitled to permanent damage.
But isn't there something fundamentally, to use a legal term, screwy, about a world in which if the LSP had said the damage here is not so severe that we can fix it, or that it is severe and it's going to be expensive, but we can fix this property for a cost of $30 million, then they have plenty of time to recover that $30 million.
That's correct.
But if the same person says, this is going to cost $30 million, the property really is only worth about $2 million, and so we're going to treat it effectively as uneconomical to repair, and we're going to treat it essentially as something in which it's permanent, then you say, sorry, too late, you knew there was contamination 4 years ago, and now you can receive no compensation for your loss. That's what you're proposing as our interpretation of this statute.
That's correct, but I mean, in no area of law can you sit upon your rights. Essentially, you have to file suit within a certain period of time because basically there's an issue with memories fading, witnesses disappearing or dying.
Yeah, but Section 4 expressly says response costs 3 years until you have, or within 3 years after the person bringing the action incurs all response costs.
Right.
So basically, when the last dime is paid for response costs, that's when the 3-year clock starts.
Right.
Well after the contamination has been known, discovered, remediated.
Right.
But if it turns out to say too expensive, can't fix it, view it as a total loss, the answer is you're out of luck.
Well,
And that's what the legislature intended?
Basically, I mean, there are different imperatives, concerns implicated in Section 4 and Section 5. I mean, Section 4 is for remediation of damage in the ground in the Commonwealth, and it's a public policy imperative to take care of those damages. So if you, as an owner or other party, incur those costs, if you step forward and incur those costs, you can recover those damages for essentially an indefinite period of time, as long as those 3 years of the remediation costs. But the policy concerns implicated in Section 5 are different. That's a private property damage. That's a private party seeking to recover damage for harm. And there is an implicit sort of time period. That's what the statute of limitations is about, is closing the books at some point on these kinds of questions. I mean, as a practical matter, plaintiffs typically bring a Section 4 and a Section 5 claim, and the Section 4 wends its way through, and that could continue, as I say, almost indefinitely. But Section 5 has to be brought to the attention of the court within a timely fashion so that those costs can be recovered timely.
But how do you do it practically? Because these cleanups are ongoing, right? And you're not going to know whether it's uncleanable for sometimes for years, right?
Well, that's precisely the point. I mean, why we shouldn't extend the statute for Section 5 indefinitely. I mean, basically, you could have an LSP who says, looks like we can clean it all up, like we can get the contamination back.
Can I add just one more factor into it? I mean, my recollection of these cases isn't great, but can't the LSP, you can create these categories. You're going to clean up to a certain level, but there is, and it's going to be usable, but there's going to be a certain amount of property damage, right? So it's not an all or nothing. It's not as if we're going to clean the entire property and then it's back to new.
Right.
Rather, we've got all these different levels of cleanup and what's expected. So you can have cleanup and recovery costs, but still not have a fully repaired property.
That's correct. And any residue of property damage that remains after the remediation has been accomplished or is expected to be accomplished, that would be private property damage under Section 5.
So how do you know you've got one of when do you know you have one of those?
Well, as according to the statute, you have to discover the fact of the damage and the source of the damage.
So as soon as you know anything, you have to bring the Section 5 property damage claim, even though you don't know whether you'll end up with one.
That is correct. There is a potential, and as the cases that my colleague, both parties cited, Hill v. Metropolitan District Commission, Black v. Coastal Oil, the plaintiffs bring both Section 4 and Section 5 claims, and in those cases, at the time of trial, it turns out that the property is fully remediable, and they don't get those Section 5 costs. But as a practical matter, the substance of litigation under both Section 4 and Section 5 is whether the party is a person liable. And if you're litigating a Section 4 case, you need to introduce a bunch of that proof, and that's the heart of Section 5. So there's not much inefficiency in requiring you to bring the Section 5 claim at an early juncture.
But the Section 5 claim, you can't really litigate it you're not going to be able to litigate it for years, so you're going to have to just put the case on hold, right?
Well, as I say, the bulk of the litigation is primarily on the person liable question of the two issues, namely whether they're a person liable and then the amount of damages. But in essence,
Well, I mean, I've done these cases. There's a lot of money very often at issue. The issue of damages is hardly a minor issue.
That's correct. And the cases that we brought before you spend a lot of time assessing those, the proper measure of damages at the time of trial.
Okay, so let's play out the Justice Kafka scenario. So I discover that this was a landfill. It appears to have been, that they appear to have hazardous waste, which appears to have been dumped on it. You're saying now I have knowledge and I need to file suit, correct?
Within 3 years.
Within 3 years. So I file suit within 3 years. The remediation effort is continuing, and the court says 2 years later, we're going to go to trial. And I say, well, Judge, that's a problem for me because I can't delineate the full scope of response costs yet, and I don't know yet whether there's going to be any permanent damage left because the remediation is not completed, so I can't go to trial. I don't know that I can tell you yet what the Section 4 versus Section 5 damages are.
Well, I guess, firstly, as Section 4, there's no, those might be ongoing, and the plaintiff could recover those indefinitely. But it's just as a discretionary matter, if that should happen to be the case, then it would be appropriate to postpone the trial until the expert testimony comes in or the remediation is complete.
So why is it so important that we say you need to file this case 3 years after you have notice, but you can't try the case, arguably, until maybe after the response costs have been expended, which is what the statute would permit if you were seeking only response costs?
For the same concerns that the statute of limitations is always implicated, basically, because memories fade. I mean, in this case, there were witnesses who were almost very, very elderly. In other states, memories, some had died. That's referring to another aspect of this case.
I'm not sure I understand that answer, though. So if there's remediation still going on, and so the Section 5 case is on hold waiting for the Section 4 case. If everybody's waiting, then the memories continue to fade. You don't have the finality that's part of the statute of limitations. So I'm not sure that the normal concerns about the statute of limitations apply if you're waiting for the remediation to finish and actually waiting to determine what exactly is and isn't permanent, because the remediation may speak to that.
Well, if I understand Your Honor's question appropriately, you're saying that the
Same
Section
concerns.
4 can implicate the same concerns. I think the question of whether the person is a person liable, whether the defendant is liable, should be litigated promptly, and it can be.
Okay, so you're saying that sometimes you'd have to do a Section 5 trial and wait on the Section 4?
Well, Section 4 obviously includes a determination that the defendant is a person
So
liable
you're saying
to.
that sometimes you should have the Section 5 trial and wait on the Section 4 trial?
Well, you should have litigation on both Section 4 and Section 5 as to the liability, And if it turns out that sort of Section 5 damages, permanent damages, need to wait in abeyance for some professional determination down the road, that they can't get it down to background levels, that may be.
Have you ever heard of that happening?
No, I mean, by and large, remediation proceeds on a sort of the same time frame as it's a 3 or 4 year process, which is maybe what the average lawsuit is in the court cases of Hill v. Coastal Oil and Black v. Hill v. Metropolitan Districting and Hill v. Coastal Oil. Like, basically, the environmental evidence comes in time for the determination of damages.
So are there any other cases in other categories, such as medical cases or construction cases, where this kind of approach is taken?
The approach that the plaintiffs are taking?
Or no, that you're advocating?
I think it's in every area of tort law. Yeah, I'm not aware of any case that requires a determination of permanency.
So you're saying then in a certain medical malpractice case or an injury case, a lawsuit should be filed the moment of the injury before the damages are known?
Yes,
Even
before
if one doesn't know. Doesn't that encourage lawsuit filing that might be unnecessary?
It's possible, but there's the competing consideration of just eventually closing the books as the statute of limitations requires. I mean, the cases say in the medical context that you don't have to know the scope of the injury. You don't have to know whether it's permanent. You just have to be injured. That's what it says, and that's what this statute, environmental statute, says. And there's nothing in the language of the statute other than plaintiffs' admittedly ingenious logical manipulations to suggest that there's an additional requirement, a third prong into the statute here. And if the legislature had intended that, they could easily have said that you have to know the fact of the damage, the source of the damage, and that the damage is permanent. They could have added a third prong and said you get the benefit of the latest of the 3 dates that you discover, but they didn't do that.
Although they did create 2 different sections covering the statute of limitations, one for 4 and one for 5, right? Why did they break that out if it was the same analysis?
Well, it's not entirely the same analysis. As I've said, there are public policy imperatives involved in Section 4.
So is your view Section 4 meant to provide a much longer statute of limitations than 5?
Yes.
Because you're going to constantly get new cleanup costs? Is that your idea?
That is our view. That it effectively, there's no end date on that. If you discover, if you remediate, you get 3 years from when you make your expenditures, and that could just keep on ticking.
Is there any guidance out there? None of the cases besides Tagenta or whatever it's called are all that
I
helpful.
believe there's a company in California called Tegeta. It says on its website. So that's.
Okay, can I ask? Was there any legislative history on this? Is there any guidance from DEP or even MCLE stuff? Is there any material out there that describes this statute of limitations? Because we're sort of left to just interpret the language and cases that aren't directly on point.
I'm not aware, as my colleague isn't either, of any guidance in the DEP or.
How about outside commentary? Anybody written on this?
I'm only familiar with plaintiffs' quite ingenious logical argument.
I know you two have written on it, but anyone else?
No.
Okay.
So I just like to say that it's not what the law is, and it's not what the law should be either. Thank you very much.
Okay, thank you.